Thank you, Mr. Chairman. Just ever so briefly, I think you and other members of the committee have heard me say before, one of my goals for the department, and the department is embracing this wonderfully, and we endeavor to respond to requests for information and act in timely fashion with regard to decisions on permitting or just simply information. I believe the strength of our position in our cases has been based on applicant failures to provide meaningful and timely requests or responses to our requests. Recent Providence Journal coverage has not been accurate, and as I said, we still have two cases.
You could knock us all. The Journal has not been accurate.
I know you're shocked.
Film at
Mr.
11.
Chair. The permitting processes that we are responsible for are based on clear parameters of water quality, clear parameters involving natural calculation of natural resource damages, risks, and in the planning assessment in terms of a total permit. We will continue to advocate on behalf of the natural resources. We will advocate on behalf of the citizens. The idea that the men and women in the Marine Patrol Division would be obligated under an agreement to tell citizens to move away, that there's an LNG tanker coming, is repugnant. We get enough criticism, deserved at times, frequently undeserved, that the mission that DEM has is not one that we want to be telling citizens who are enjoying sailing, fishing, recreating, or just the view of the bay that they have to leave is unacceptable to me. And I would quit there, given your wish to have the committee keep to a timely matter. Marissa Desatel again is here with regard, and she may have a few comments. I know she has a few comments with regard to the technical merits of the litigation, and so I turn the microphone to Marissa.
Director, thank you very much. I do want to note that Senator Susan Sosnowski has joined us, and thank you very much, Senator. I understand you had some other obligations. And Director, thank you very much for your usual brevity. And now, if you would proceed, young lady.
Thank you, Mr. Chairman. Again, I'm Marissa Desatel. I'm a senior legal counsel at the Rhode Island Department of Environmental Management. I've had the pleasure of working on the Weaver's Cove project since 2007, and I will be very brief. I just wanted to let you know of the past litigation that is now over, and the ongoing litigation that, like the director said, is still an option for the state of Rhode Island to try to stop this project. So the first case that I'd like to tell you about is the lawsuit filed in Washington, D.C. on June 27th of 2007. Weaver's Cove filed a lawsuit against DEM alleging that we had failed to act within a statutory, federal statutory one-year deadline under the Clean Water Act. That appeal was ultimately found against Weaver's Cove, so Rhode Island kept the dream alive, so to speak, and we were able to continue on with the merits of the application. The next lawsuit that was filed was in the First Circuit. It's a federal appeals court located up in Boston on September 7th of 2007. That had to do with more of the merits of the department's ultimate denial of Weaver's Cove's water quality certification application. That request for review was brought under the Energy Policy Act. That case was recently dismissed without prejudice in May of 2009. And so, again, we're brought back to the state level of appeal. As the director mentioned, we do have an ongoing Superior Court appeal. Weaver's Cove filed that on March 11th of 2009, and that's generally just the standard Administrative Procedures Act appeal, where they request a judge of the Superior Court to look at whether or not the agency acted in a manner that was either arbitrary or capricious. That is currently stayed pending the outcome of other federal action in this case. I apologize, it does get a little confusing, but I'm getting near the end. The last case that I wanted to tell you about that's ongoing is the U.S. District Court for the District of Rhode Island. That was filed against DEM on March 11th, 2009 as well. Weaver's Cove is seeking declaratory and injunctive relief, alleging that the state laws having to do with the dredging permit that they filed with DEM are preempted by the Natural Gas Act, and also that our state laws on the issues contained in the permit process are a violation of the Commerce Clause of the U.S. Constitution. So of those 4 cases that I just mentioned, the Superior Court appeal is alive, and the federal challenge under the Constitution is still alive. I will end my summation there, but I am available anytime if you have any questions, so feel free to contact me.
All right, thank you very much. And believe it or not, your discussion was interesting to me as a lawyer. I'm not certain how it worked for the other members of the committee. Senator Miller did indicate that. Did you want to ask a question of more specificity?
Just briefly, if you could go over the differences between the current Providence facility and your obligations to that facility and the proposed Weaver Cove.
I don't believe that that would be a question directed to me, right?
And Marissa is empowered to kick me under the table if I get towards a legal point. Thank you, Senator Miller. I think the primary difference between an established facility and a proposed facility is the disturbance in the channel, the disturbance in the dredging, the estimation of damages for a proposed facility versus an established. And I think that's the best answer I can give you at this point in time.
That question, if the Attorney General could also respond to that later in writing.
All right, thank you. Senator De Palma?
Thank you, Chair. Director, with regards to the 4.5-mile, as I call it, pipe in a pipe, I recall testifying at the hearing that was held at Mount Hope High School back summer of 2008, I think. It was a good year. No, I think that was around the time frame. It was a rainy night. I still remember running into the facility, and at the time, the Coast Guard, Captain Perry at the time, was there. They were taking official testimony for and against the project. And when I asked the question regarding the 4-mile plus pipe in a pipe, 48 inches, 36 inches, I think is what it was, or 48 and 24, I had asked the question because they talked about they had done simulation of this. And as an engineer, and as Senator Felag would also testify or specify, I think, simulation is one thing. When I asked the question, where had they done a pipe, an installation of this magnitude of a pipe in a pipe, the answer was, we've never done this. This would be a first of its kind. And so my comment to him was, I understand and appreciate simulation. Simulations are very valuable. But the first, having worked in defense and homeland security, understand and appreciate the value of simulation. But when we go and do that first test of whatever it is, a lot's learned. A lot of things happen, a lot of problems occur. So to get quick to the question, I don't want to belabor my comments anymore, what type of analysis has DEM acquired with regards to this 4.5-mile pipe in a pipe that's never been done before at this length for liquefied natural gas?
I think you ask an immensely valid question, but I would respond by saying none of the pipe is within Rhode Island waters. And therefore, what opinion I might have would be, I think, irrelevant to our case.
Okay.
I would tell you as a recovering academic, not only is the simulation versus the reality a very valid question, we are also, questioning there are reports, scientific reports and evidence of seismic fault and flaw, and so stability analysis of that pipe would be valid. We are asking the question, and we believe in one of the matters that is before jurisdictional bodies is we believe that Rhode Island has the right to have opinion, comment, and respond to activities in Massachusetts as they may impair Rhode Islanders' safety, enjoyment, and use of the resource. And there are others who feel we do not have that right. And so we will endeavor to commit to assisting our sister state, but that's as far as I'd wish to go on that, Senator De Palma.
Mr.